But it does give me an opportunity to go to Tanya Miller, because we talk about this day, Tanya. We talk about the tension. You have been in courtrooms where you're waiting for that verdict. What's that like for you, your clients, as you're waiting on a jury to determine your life and the fate of your client?
It is a feeling like no other, Ryan. I mean, you are literally sitting there waiting for the ball to drop, either on you or just to miss you barely. So there is tension, there are butterflies, there are nerves. So it's a stressful time, and you really have to do your best to put your poker face on, to remain calm if you're a defense attorney, to help keep your client calm, to prepare your client for whatever happens, because you don't want your client to explode in glee if he is acquitted, or fall to pieces and do anything that might damage him later when it's time for sentencing in front of the judge. And if you're a prosecutor, you're doing the same thing with your family. You want to prepare them for the worst, and also to prepare them how to act with the appropriate decorum in the courtroom should they get a verdict that goes in their favor.
And I want to ask a specific question, just thinking about passing of the time now, 5 hours and 37 minutes. And what exactly are they doing? Maybe I'll throw this to Tanya Miller. In terms of literally passing the time, they are possibly in just a room where they're allowed to wait, let's say the defendant's family and the victim's family. How do they pass the time generally? Are we talking about playing cards? Are we talking about reading a book, reading the newspaper? What do they do?
It really depends on the family, but what they're mostly trying to do is just relax. They're trying to stay calm. So that could mean that they are talking or chatting either about the case or something totally different. I've had victims' families that prayed. You know, they get in a room together, they hold hands, they might have a clergy member there with them to just really pray over them and to help them through. I've had victims' family members who feel a sense of relief. They feel like the prosecution did their job, and no matter what happens, we feel good. So they go out and they eat dinner, and they've given it sort of over to the jury to do what they will with it. They've been satisfied with the process. So it really depends on the family, and it really depends in large part on the situation and what's at stake.
Yeah. And you know what? 5 hours, 38 minutes and counting. We do know the parties are in the courthouse. They're standing by, folks. This isn't, we're going to go an hour or so away and come back. They're standing by. As soon as we know a verdict is in, or if there's a question, if there's a request, the judge, they're going to tweet it out, right?
Yes,
they're going to tweet it
absolutely.
out, and then everybody's going to come to the courthouse. The judge will not leave anybody out. Want to give you the stakes here, because it's important to think about it. The jury deliberating, 14 days of testimony. The charge, second-degree murder, 25 to life is the sentence. There's also manslaughter as a consideration, if not second-degree murder, or not guilty. And then, of course, we mentioned the possibility of a split. They can't get a decision. We'll see how that goes. But in the meantime, we're going to come back. We talk about what the families are going through, Jane. But the other side of this is, what do the jurors go through? They know they're making a decision that is going to change the lives of people in that courtroom that they've been looking at every single day. What is that like for them?
They have an opportunity to speak at the end of all this, or not speak.
Right.
And so they may decide, whatever their decision, they want to leave, and they want to get out of this case, and they want to resume their lives without having their faces and their names associated with a very controversial case.
We will see. They're deciding the fate of George Zimmerman, and when we find out what that is, you're going to find it right here on HLN.
During the final arguments by John Guy, I was able to see a couple of the jurors actually crying. Crying. And at first I was trying to brush it off like, okay, maybe this isn't happening. But you see one juror wipe the eye, and then the next one wipe the eye, and then somebody is like full on. And then the blonde woman in the corner, she actually got red, and she was shaking because she was crying. So
unbelievable.
The jury deliberating now 5 hours and 42 minutes, and we're trying to read the tea leaves and trying to figure out what they might be saying, doing, thinking right now. We know some things about them. There are 6 women. 5 of the 6 are mothers, and 4 of the 6 have some connection to weapons. One had a concealed weapons permit at one time. Some of them have family members, husbands, and children who have weapons. What can we deduce from that, if anything? I want to toss it out to Tanya Miller. Essentially, we like to make conclusions based on what we think we know about people, and a lot of times those conclusions are wrong. Isn't that the entire message of this case? Never assume by looking at somebody that you know what they're thinking or what they're doing. If that's one lesson that we should learn from this case, it's that. And yet, here we are trying to figure out what these people are thinking and doing based on these assumptions.
Absolutely, Jane, you're absolutely right. Look, trial lawyers have a famous saying, we all say it, you never know what the 12 will do. In this case, we're talking about 6. But the truth of the matter is, you don't. Anyone who's ever tried a case in front of a jury and has tried to read either facial expressions or body language to any degree of certainty has found themselves to be wrong over and over again. You just cannot predict what they're going to do back there. You can't predict how they perceive certain evidence. You can't predict what issues really strike them and hit home with them. Oftentimes, as prosecutors, you think that you have made a certain point and it is the critical point in your case, and the jury gives you that conviction, and you go back there and talk to them and ask them, well, what was it that really convinced you in the case? And it's something totally different from what you thought. You know, they have alliances back there. They start off thinking one thing about the case, and then after they interact and deliberate with each other, they reach other conclusions. So it's always a difficult business to be in, to try to predict what a jury will do.
The other thing is, you never underestimate the messenger either. I've talked to juries after trials, and they've sometimes said, I really like that guy. I really like the way that guy dressed. The messenger is important as well. The evidence, of course, being the most important thing. But I got to bring in Sue Constantine.
All right, really?
Really, Jane?
That was seriously, Ryan? That was a theme. Maybe it was working overtime. It was good to a certain degree that it was like, okay, a little bit too thematic, laying it on a little bit too thick. But, you know, I find that this is all such an imperfect science. And speaking of science, we were talking about something absolutely crucial to this case. What really got it all started in terms of national outrage was, they say the medium is the message. That was Marshall McLuhan, right? Who said it's not just what you say, it's how you say it and the vehicle you use to say it. And there was a sense, and I'll throw this out to political science professor Jason Johnson, that there was a tremendous insensitivity in how the message was delivered when they initially decided that because of stand your ground or for whatever other legal reason, they felt, the powers that be here in Sanford, that they could not file charges against George Zimmerman.
Look, you have a movie coming out this month called Fruitvale Station about Oscar Grant, about a black man who was shot, who was essentially innocent, you know, at a train station. There is legitimate skepticism on the part of many people in this country of all races that the police pick and choose how they will enforce and how vigorously they will investigate different cases. And again, if you have lost your child, you're going to do anything in your power to find out the truth. And again, we go back to John Guy's closing. If this was reversed, if Trayvon Martin were driving around and followed George Zimmerman, don't you think, I mean, George Zimmerman's parents would say, what do you mean? What do you mean? Our son is dead. He was walking home. So I think this is another example of how we are so free in this country that if we don't like what the police are doing, we have the liberty to complain, to agitate, and see if we can get justice.
So, Jason Johnson, let me touch on that as well. Do you think the verdict in this case is going to adjust that feeling on behalf of groups who feel maligned in that way, who feel like the system doesn't work to their advantage? Do you think a guilty or not guilty will adjust that in any way?
I'll be perfectly honest with you. No. Nothing changes with this verdict. And I know no one wants to hear that, but guess what? If George Zimmerman ends up getting off, for a lot of people will say, oh, a group of Southern white women said it's okay to kill a 17-year-old kid. There's nothing's going to change. If George Zimmerman is found guilty, then it means that, okay, Jesse Jackson, Al Sharpton, the president, and the Justice Department had to get involved to get local cops to do their due diligence. There's no victory here for either side politically. So I don't think anyone's attitudes are going to change. Maybe a family will be relieved either side, but the verdict's not going to change people's attitudes.
Mike Brooks, HLN law enforcement analyst, weigh in here because you deal with law enforcement, and the suggestion is that, well, they certainly mishandled the communication, that they didn't feel they had enough charges. Irrespective of whether they had enough charges or not, it was also how they communicated that message.
Look, Jane, right from the very beginning, Ryan and myself, Vinny, I was one of the biggest critics of the Sanford Police Department on what they were doing or what they weren't doing in this particular case. But then as more discovery started coming out, we saw that, yeah, they were going through the neighborhood. Yes, they were interviewing people. Yes, they were taking statements. But the problem is, did they have at that time, because of the laws in Florida, did they have enough probable cause to arrest George Zimmerman at that particular time? So, I think Chief Lee, he basically got thrown under the bus because he was the one that came out there. And keep in mind, Detective Serino originally wanted to charge him with manslaughter, but it was decided by the local circuit there, by the state's attorneys, that there wasn't enough. Who else was involved in that? We don't know for sure. But then the special prosecutor, Angela Corey, was brought in from the 4th Judicial Circuit to kind of oversee this, and that's when things started to change. But Serino, he was doing his job. He thought there was enough probable cause for manslaughter, but he apparently got shot down by someone.
Yeah, and now he's bitter. And that showed up on the witness stand.
I don't know if it was bitter or
he
just
was
being
bitter.
honest.
Yeah, you never know. You know,
That's right.
You know what, folks? We're going to be right back. We're going to take your calls. Hey, Jane and I are starting to hear helicopters coming up from above. You can sense the presence is here. The tension is here. People are waiting on pins and needles for those 6 women. They call them the Seminole 6 to decide the fate of George Zimmerman.
And they are working through lunch. And it's lunchtime right now. What will they decide?
Welcome back. You're looking at the Great Seal of the state of Florida. That's inside the courtroom. And once something's happening in that courtroom, we will back up. You will see the parties gather. They're all nearby, and we will put you in that courtroom. So will it be a verdict? Or could it be a question or a request? We've had one request so far. A list of all the evidence makes sense. There's hundreds of pieces of evidence.
Yeah.
The question is, what are they doing with that list? Where do they stand?
No substantive question, and
Right.
that's what's significant. And now I could say we're hitting some significant time.
Right.
We're getting into that, could they be at odds in their time period? Or maybe they're just going over the more than 200 pieces of evidence. Meanwhile, we are talking with our fantastic legal panel about who did the better job. So I want to throw it out to Tanya Miller. You've been listening to everybody, and we're all been talking about how handsome Prosecutor John Guy is. We're going to stop that conversation, and we're going to move on to some more substance.
Right. I actually think that the prosecution really did a better job in closing. I certainly think that Mark O'Mara is a very good lawyer and really had some really great days in court, scoring points from prosecution witnesses, really making sure his theory of the case got across to this jury all throughout the trial, and I thought that that was very good and effective. But I have to say, in closing argument, what you saw John Guy do, that's what they teach you to do in law school. That's the thing that only a few select talented orators can do standing in front of juries. He was passionate. He was emotional. He did not scream. He did not yell. He did not need props. He was able to paint a picture that I think was far more clear than even that animation that the defense used, just with his words, with his imagery. I just thought it was a fantastic closing argument. We'll see if it's enough ultimately for the prosecution, but just in terms of performance, I gotta give it to the prosecution.